All right. Well, Gilbert Ambler, right?
That's right.
Thanks for being here today. You're about to open up a class at the Green Top Shooting Range this afternoon, and thanks for coming in earlier to sit down and talk to me and talk to our listeners and our customers about a little bit about what's going on with not just U.S. Law Shield, but we got a lot of crazy stuff going on in the state of Virginia right now.
Very interesting time to be a gun lawyer in Virginia.
I'll bet, yeah. First, so tell me a little more about yourself and how you've gotten hooked in with U.S. Law Shield.
Yeah, so I've represented Law Shield here in Virginia for, I want to say, 6 or 7 years at this point. I also represent them in Pennsylvania and in Maryland. I'm licensed in Pennsylvania, Maryland, D.C., Virginia, and North Carolina. So I kind of have a broad base that I'm licensed to practice in.
All right.
And my practice is very firearms focused. So it's not just self-defense that I do. I do constitutional litigation involving firearms. I represent and have represented Gun Owners of America, Virginia Citizens Defense League, some of those other firearms organizations. And then my practice does everything from sort of compliance matters, dealing with helping people understand the NFA and the requirements under the NFA and what they can do, what they can't do, how to go about fixing problems with the ATF, all the way up through gun rights restoration issues.
Okay.
And then, of course, litigating self-defense matters.
So civil rights as well, as far as gaining your gun rights back, things like that.
Getting gun rights back, and then civil rights in the context of litigating constitutional issues. Because the way I see it, when we talk about those constitutional issues, those are civil rights as
Absolutely,
well.
yeah.
And so
we want to keep it that way.
That's right.
Yeah.
So litigating those matters. And that's something I'm passionate about. That's why I wanted to go to law school in the first place, was I care about the Constitution and the rights that we have, and I care about all of our constitutional rights. And I say this repetitively, but the Second Amendment to me is the canary in the coal mine. When it starts to disappear, you know the other rights are going to follow.
Oh, yeah, absolutely. Before I forget, I've got a little something I'm drinking here. It's some coffee, but thanks for being
thank you so much.
A guest on the podcast.
I appreciate it.
That is a Green Top.
It looks just like that.
It looks just like that. It's a Green Top Yeti. Shout out to Yeti. Yeti does a lot for us. We do a lot for them as well. We're probably one of their biggest independents in the country, but they always help us out. So we like to hand those out to folks. Yeah.
I appreciate it. And I've got some Yeti products already, so I won't sit here and plug Yeti all day, but I enjoy them. So,
well, let's talk about U.S. Law Shield a little bit. And that organization, we've been tied in with them for several years now, and you guys are busy, especially this year.
We are busy. Unfortunately, there's always cases popping up, and there's always people needing help. And that's one of the things I always, when I talk to folks about Law Shield, I often hear this sort of doubt in people's mind. Well, am I ever actually going to have to use that? Is that really a thing that comes into play? And I tell people at any given time, just within Virginia, any given time, I probably have somewhere between 3 to 6 cases going on for Law Shield. And new cases cycle in it all the time. Old cases cycle out, depending on the nature of the case and the severity of the case and where we are in the procedural posture. Cases can be wrapped up as rapidly as a couple months to a couple years. So, I can have cases that hang around for a very long time. There's also cases that come through quickly, but the underlying factor is there's always new matters popping up. There's always people that find themselves in situations where all of a sudden their Law Shield membership is stepping up and helping them. And so we like that on the legal side because we know we're getting paid when these folks have issues.
So the people you're representing at any given time that you call a Law Shield a customer, they are a client of U.S. Law Shield, and you're helping them in some sort of legal matter.
They become a client of my firm at the point Law Shield says, yes, this is a covered incident.
Got it. Okay.
Yep.
Got it.
And so that's everything from assault cases and shoving matches to lots of brandishing cases, as you might imagine. Far and away, more than anything else, I see brandishing cases.
Well, you bring up brandishing. I mean, that's a topic I think a lot of people should probably know a little more about, and what brandishing truly is, and what are the repercussions there.
Sure. And so brandishing, and it's important to know, it's not just brandishing. I mean, it's brandishing all the way up to murder cases that come in through Law Shield. But brandishing is common, and the reason brandishing is so common is the Virginia Supreme Court has really, in my opinion, sort of unfairly broadened the definition of what counts as brandishing. So brandishing is found at 18.2-282 of the Virginia Code. It's a class 1 misdemeanor, which means it's punishable by up to a year in jail and a fine of up to $2,500. And I will say that is a significant penalty. Up to a year in jail, fine of $2,500 is not something you thumb your nose at. It's not as serious as brandishing like conduct in other states. For example, up in Maryland where I practice, what we would call brandishing here in Virginia with a max of 1 year penalty. If, assuming you've got a Maryland wear and carry, you're entitled to carry the firearm with you. If you are charged with brandishing like conduct, and I say brandishing like conduct because they don't have a crime called brandishing there, but the penalties that you're going to be facing, you're going to see first-degree assault, second-degree assault, use of a firearm in commission of a felony. You're going to be facing 5 to 55 years on that trio of charges in Maryland. And so brandishing is something that is commonly litigated through lawsuit. The severity changes depending on what jurisdiction you're in, obviously.
We don't want it. We don't want Virginia to shift that way.
Well, pay attention because we're starting to slide that direction.
Elections have consequences, right?
Elections have consequences. Coming back to what brandishing is and why we see so much of it in Virginia and what the Supreme Court in Virginia has been up to is when we talk about brandishing, it's holding or pointing a firearm or an object similar in appearance to a firearm. It doesn't have to actually be a firearm in a manner that causes reasonable apprehension in the mind of another. And it's not just pointing, holding also counts. And then the question is, what type of holding? And Virginia's Supreme Court started in a case called the Morris case. The Morris case had a bunch of bad facts. That case has been built upon by the Court of Appeals, however. The Supreme Court in Morris said the type of holding that is criminal holding when it comes to brandishing, the type of holding a firearm that will get you in trouble is holding it in an ostentatious, flashy, or aggressive fashion. And so ostentatious, if you go to the dictionary and pull that definition, ostentatious is drawing attention to oneself. And the reason this, in my mind, is so significant is I think probably everyone would agree if you're holding a firearm in an aggressive fashion that is scaring other people without justification, there's not a reason for you to do it, you deserve to be in trouble, right?
Sure.
You run around aggressively pointing a gun at people without provocation, sure, you deserve to be prosecuted.
Yeah.
Once we start talking about prosecuting people for simply drawing attention to themselves while carrying a firearm, we start to hit all sorts of other conduct that opens the door to brandishing that is not aggressive in nature, right? I'm thinking of protesting.
Yeah.
I see people protesting while carrying firearms. They're trying to make a point. Hey, I lawfully own these firearms. These firearms are not a threat to you. I'm carrying them to make a point that I should be allowed to keep these. It is my God-given right to have these weapons. Well, if you're drawing attention to yourself with a firearm and somebody claims to be reasonably scared by it in Virginia, the Supreme Court has opened a path to prosecution for brandishing, and there are prosecutors in Virginia that would happily make that point.
Okay. All right. So, and then obviously the definition of brandishing, like you mentioned before, it differs. And what one person thinks brandishing is versus another, I mean, it's another reason why, I guess what I'm trying to say is if someone simply is open carrying in Virginia, how much worry should they have in someone classifying that as brandishing? Because open carry you can open carry just about anywhere in Virginia, and then obviously in some places that it's restricted. But are there any signs to where anyone should start to worry about that? I mean, openly carrying in a protest or some sort of like downtown, a couple weeks ago at the Capitol.
Sure.
People could portray that as brandishing, or
I think they could. And take this all with a grain of salt, because I think my nature as an attorney is always, when I give advice, to be as cautious as possible, which means I'm going to say, hey, you should be cautious about this activity because I can see how it could go wrong.
Sure.
And that doesn't mean it actually is going to go wrong.
Right.
That being said, I think knowing your jurisdiction, knowing where you are, there is things you can do in, out where I live in Frederick County, Virginia, that if I did in Arlington with a firearm would get me prosecuted.
Right.
So knowing your jurisdiction is going to be important. And then paying attention to sort of the shifting winds of the political spectrum, because we're seeing that right now in everything firearms related. And in a certain sense, what we're doing is by penalizing firearm owners and firearms and really making firearms this bad guy, this boogeyman out there. You should be worried about these certain types of firearms, et cetera. We're giving anti-gun judges and anti-gun prosecutors fuel to their fire that I'm justified in being afraid of a firearm. And you know what? I'm going to prosecute somebody because they did something that scares me with a gun. And a lot of times they're scared because they don't understand what they're dealing with.
Yeah, I mean, you don't want to be the person they want to make an example out of.
You don't want to be a test case. It's not worth being a test case.
Exactly. Yeah. All right. Well, let's move on towards I guess the hotter topics right now, and that is the gun legislation that has moved through the General Assembly that is awaiting the governor's signature, and that is the big one that everyone's talking about is the assault weapons ban.
Sure. I am extremely apprehensive that this is, as I think it always is when people are coming for your rights, that this is a calculated method to take away rights a little piece at a time. And here's what I mean by that. They have told us we're going to grandfather everything you already own. You get to keep, great news, folks. You get to keep what you currently own.
Right.
And that is a relief to some folks. In a certain sense, it's a relief to me because it means I don't have to imminently give up anything. But I also heavily suspect that it's going to get worse next year.
Sure.
I suspect that during the 2027 legislative session, what we're going to see is a registration requirement. Because when you really zoom out and think about it, it's all well and good to say you can keep what you already own. You just can't have anything new that meets the definition of an assault weapon past July 1st, 2026. But that's difficult to enforce. I mean, absent you getting nailed down with something stupid like, you've got an AR in your possession, the serial number, when they trace it, comes back to a manufacture date post July 1. Absent something really stupid.
Right.
If they catch you with what they deem to be an assault weapon and you keep your mouth shut, the burden's on them to prove, hey, you got this after the effective date. So how are they going to prove that? Well, that's why I say I think they're probably just chipping away at things, and they're doing it in such a manner that they hope people don't stand up and people don't show up. And if you remember back to 2020 and Lobby Day in Richmond in 2020 when you had 20,000 people at the Capitol, that's what they were doing in 2020. In 2020, they said, we're going to have a registration requirement. That way we know what you own. And sure, we'll grandfather certain things in, but only if we know that you already own them. They went about it a different way, and I think that is evil and calculated because I think they did that expecting that people would not show up because, sigh of relief, you get to keep what you already own.
Right.
And I think it's going to get worse.
Yeah. Yeah, I mean, as these bills started to get proposed early on, the bill was way worse. And, it's funny, somebody here was saying, well, I'm just glad it's not as bad as it was. And I said, well, it's easy to say that, but I mean, I'd rather not be, facing this at all. I mean, right now, obviously, business is great if you're a firearms dealer. Until July 1st, when things could really go downhill.
Sure.
But business is good, but I'd rather it, I hate saying this, I'd rather it not be for these reasons.
Sure.
I mean, this is like you said, this is just step one. Step two comes next year. I mean, we don't know what's coming after that. There's a lot of scary stuff that got tabled.
I do know what's coming after that. I mean, if you zoom out and look at history, it's registration and then confiscation. That's what comes eventually.
And I worry about other states too, because if other states see that, oh man, if this can happen in Virginia, we can go for that in this state. And then there's other elections around the country that it could potentially have the same results. But what I think people are misunderstanding about this bill is simple things like things that are grandfathered, magazine capacity. I think there's still some people are unclear about what to do with a assault weapon after July 1 if they wanted to dispose of it or they don't want to own it anymore. They want to sell it to somebody.
Yeah.
Can you kind of talk more about the specifics of that in particular?
So I think, first off, people have a good reason to be confused. And they have a good reason to be confused because we have used here in Virginia this legislative session 3 different definitions of assault weapon in 3 different places in laws. Yeah. So we've got one definition of an assault weapon if you're an 18 to 20-year-old and you're going to be prohibited in the future from purchasing an assault weapon, which is already kind of interesting because they're banning the sale of assault weapons generally. So that's sort of duplicative, right? They're saying if you're 18 to 20, you can't purchase an assault weapon, but also no one can purchase an assault weapon.
Right.
maybe they're hedging their bets. Maybe they're worried the assault weapon ban broadly gets struck down, but they're trying to preserve a second level that would disallow transferring to an 18 to 20-year-old.
Right. I never thought of it that way. Yeah, that's right.
And then we have a different definition of an assault weapon when it comes to carrying and transport. You can't carry on or about your person an assault weapon post July 1, 2026. So different definitions for acquisition, for transfer to certain age groups, for transport. So there's an absolute good reason that people should be confused. And unfortunately, as any judge will be happy to remind you, ignorance of the law is no excuse.
Sure.
So you don't get to show up in court and say, well, Judge, I used the wrong definition of assault. I was a little confused here.
Right.
Ignorance of the law is not an excuse.
Right.
Now, maybe it should be when you write laws this poorly. And look, there is always other legal theories that can be used. There's a concept out there called constitutional vagueness. If a law is so vague that the average person can't understand it, that law should be void, because laws are written to be understandable. You should be able to know right from wrong. Here's what I'm told I can do. Here's what. If no one gets it, then that's problematic.
Right.
Coming back to the grandfathering and your question about post, so you've got weapons or magazines that are grandfathered. What can you do? Well, that's another distinction right now. The way the law is drafted, and of course, the time of end of March, we're recording this. The governor can have these laws go into effect through inaction. So if she does nothing, they become law. She can sign them and they become law. She could veto them, which isn't likely to happen, or she could make suggestions and return them to the legislature. So there are still things that could change.
Sure.
As currently written, things that meet the definition of an assault weapon, you will be prohibited from manufacturing, transferring, importing, etc., but possession would be allowed. And there are exceptions to the transfer. You can transfer them to a close family member via gift, not via sale,
right,
but via gift. You could transfer to a close family member, which would include spouses, parents, grandparents, children. You can also do things like sell them to an FFL who could sell them out of state, etc., post July 1. You won't be able to acquire new ones. The magazines, they've got a separate code section, which is a high-capacity magazine, their term, not mine. Hits any magazines capable of holding over 15 rounds. The magazines, again, grandfathered for possession. You get to keep what you already own, but you can't transfer them, which the sort of farcical thing that comes up here is I can give my children ARs that are in my possession, but I can't give them the magazines that are sold with the ARs, right, the standard capacity magazines.
Right.
And I'll tell you, my workaround for this is I've acquired a bunch of magazines in my children's name. I've got a 2-year-old that owns a bunch of PMags because there's no age limit for how old you have to be to own PMags.
That's right.
And so I ordered a bunch of mags for my 2-year-old and my 4-year-old. That way they own the magazines, and if down the road these laws, and hopefully these laws get struck down and we don't have to worry about this, but if down the road I give them the weapons, they already own the magazines that would be associated with those weapons. So that's my quick workaround on how to get past that.
Gotcha. That sounds good. Are you surprised they went, because initially it was 10 rounds. Are you surprised they went to 15?
Not at all. I think that's tactically, again, to me, there's some calculated evil here.
Sure.
And I think the calculated evil here is they see the writing on the wall that the 10-round limit is going to have it's going to cause judges to really look at it sideways. And look no further than D.C. D.C. is not typically a gun-friendly jurisdiction, but we just saw the D.C. Court of Appeals say, hey, 10-round magazine limit is problematic constitutionally. And so by bumping it to 15, they have created wiggle room for them to come into court and say, Judge, forget about it. Those 10-round mag limits, those are unconstitutional, but 15 is totally okay and factually different. So you don't have to. That's not even persuasive what that judge in D.C. said.
Right.
So they're setting up wiggle room for themselves there. And keep in mind, we talked about how elections have consequences, setting precedent that other states might. In a large part, what we're facing here in Virginia is a consequence of all the negative stuff that has happened over the years in Maryland, because they are bolstered by the fact that the Fourth Circuit and the judges on the Fourth Circuit have allowed this stuff to go on, have said arms that are militaristic are not protected by the Constitution, which I think is a poor reading of case law. I think it's a poor reading of the Constitution itself. And I think it's contrary to what the Supreme Court has said. But I'm not a judge on the Fourth Circuit. So my opinion is good insofar as I get to show up and argue these things, but it doesn't mean we win these things.
Do you think there's enough challenges out there eventually to where the Supreme Court's going to have to take on a case around this?
I do. I am hugely disappointed that it hasn't happened already.
Right, yeah.
Maryland's assault weapon ban, if you remember, that went up. It was GVR'd, which is grant vacate remanded by the Supreme Court after Brune, sent back down to the lower court to say, to the Fourth Circuit to say, reconsider this in light of our decision in Brune. The Fourth Circuit purported to reconsider and send it back up with the same result. Hey, okay to ban assault weapons in our eyes. And at that point, the Supreme Court didn't take the case. You had, my recollection is you had to have 4 justices vote to take it. You had 3 vote for it, and then you had Justice Kavanaugh write an explanation saying, I think we need to take one of these cases in the near future, maybe within the next term or 2. And so he essentially deferred on that, and who knows when that will be. I mean, there's a lot of speculation that a circuit split, one of the cases out of maybe the Third Circuit might cause a circuit split, where maybe and the Third Circuit has not historically been viewed as pro-gun either. I practice in Pennsylvania, so I deal with the Third Circuit as well. Not traditionally viewed as pro-gun, but we've seen some pretty pro-gun decisions lately, certainly more so than the Fourth Circuit out of the Third Circuit. And if you get that circuit split where the Third Circuit says, hey, it's unconstitutional to ban assault weapons, Fourth Circuit says totally constitutional to ban assault weapons, that's something that is very likely for the Supreme Court to take up, because the Supreme Court does not like the country operating with different rules in different parts of the country. When it comes to the Constitution should have the same meaning everywhere.
Sure.
So how can it be okay to ban these weapons in Maryland but not in Pennsylvania? It would be a logical problem.
Yeah. Yeah, I don't know. I mean, I'd like to think they're going to hear it soon because it's so amplified right now, and it's going to get bigger and bigger and bigger. But some people think, well, maybe it's a good thing they're not going to hear it. Maybe this isn't the time they want to hear it. I mean, maybe the decision's not going to be in our favor on this. I don't believe that would be the point, the outcome, but I don't know. We'll see. The point though is Virginia is heading in the wrong direction on the gun legislation side, and we can talk briefly about the civil liability piece as well. It doesn't really affect the citizens of Virginia, but there's a piece where dealers, manufacturers, sort of get a bullseye on their back.
And I strongly disagree. I think it's going to have a huge effect on the citizens of Virginia, because it's going to put gun stores out of business. And it's going to put gun stores out of business not just because they get sued for something. It's going to put them out of business because their insurance is going to go up. Insurance providers won't want to cover them.
Yep.
And frankly, there are going to be gun stores that are looking at their profit and loss statement, and they're going to be saying, I haven't been sued yet, and I'm going to quit while I'm ahead because I'm not making enough at this to go through a civil lawsuit.
Right.
So I think it's going to have a huge effect on the citizens, because I think it is a harass gun dealers bill. I don't think that, and we were talking about this a little bit before we started recording here, but they haven't really defined these terms. You've got to have reasonable controls. You can't be creating public. I mean, these are undefined terms. They didn't provide definitions. They just slapped this law up there. And I think it's designed to scare gun stores. I think it's designed to drive gun stores out of business, to drive insurance up. And maybe we'll see judges start to really narrow this down. And frankly, it's a attempted way to circumvent the PLCAA, the Protection of Lawful Commerce in Arms Act, which is a federal law that should supersede state law. Without boring the listeners, the federal law has a problem called the predicate exception, which is problematic, and Congress needs to step in and fix. It's what put Remington out of business.
Yeah, that's right.
And that's what Virginia's trying to essentially create this loophole under the predicate exception of the PLCAA. To the extent that they will or won't be successful, I don't know. I'm kind of leery of how successful it's going to be. If gun stores are smart, I think the bigger effect and the more widespread effect it's going to have is scaring people out of business.
Yeah.
Not Green Top. I don't think Green Top's going to close their doors and say, we give up.
Right.
But the little ma and pa gun
mean,
store somewhere is going to do a quick math on the back of a napkin and say, hey, we can't afford a lawsuit.
Right. Nobody wants that. I mean, It's a bad thing for small businesses, and like you said, to a lot of citizens that love their local gun shop or whatever that is all over the state. Yeah, you got to worry about your favorite little gun shop potentially going out of business or people targeting them for lawsuits. And then if that's going to happen here, what's to say it's not going to happen in North Carolina next, South Carolina or wherever? I mean,
it's also the people that might get sued under. It's going to be like sort of winning. Well, two things actually, as I'm talking about this, that occur to me. First off, you're opening a door for the anti-gun groups to get involved because with a statutory cause of action, you're going to set up Brady, Everytown, Giffords, and the like, and we already see them. For what it's worth, we already see them dogpiling in litigation. When we sue a city that passes unconstitutional gun laws, the city is often not expending funds defending it. They're turning to Brady and Everytown, and these big organized anti-gun groups are coming in saying, you can go ahead and pass stuff that you even think is unconstitutional, and you don't have to worry about defending it because we'll come in and we'll fund the defense.
Right.
So they're out there, they're organized, and they will, of course, be using the statutory cause of action to come in and sue Virginia shops. The second thing is it's going to be like the bad luck lottery. You happen to sell accessories that get used by a bad guy in a bad act, and it's on the news. Congratulations, there's a statutory cause of action for you to be sued.
Yeah. Well, I'm trying to think of anything else in this bill because, like you said, it's broad. It's very confusing. A lot of people don't realize they're really targeting they think this just targets AR-15s, but there's a large number of handguns that fall under this definition of assault firearm that have threaded barrels, that have high capacity magazines, and then let's not forget there's about 20 different turkey hunting shotguns on those racks out there that will become illegal after July 1 because they have a pistol grip.
So the interesting thing is, like looking at handguns, for example, is you've got one definition of an assault weapon when it comes to acquisition of the weapon. So you're looking at centerfire handgun, detachable magazine. That's sort of our predicate. Are we heading into assault weapon territory? Once we're centerfire detachable magazine, yes, we've got an assault weapon. They've got a different definition for centerfire with a fixed magazine, but most handguns we're worried about centerfire detachable magazine. We're in assault weapon territory if we have two offending features. So for a handgun, we'd be looking for threaded muzzle plus a buffer tube that is designed to facilitate, and that's interesting language, and it's designed to facilitate shooting from the shoulder.
Right.
That's what gets us into assault weapon territory for purposes of acquisition. For purposes of carrying an assault weapon, which will be banned on public streets and in public locations after July 1, we're looking for a handgun that is centerfire detachable magazine with only one offending feature. So you'd still be able to come into the shop and buy a Glock that has a threaded muzzle, centerfire detachable magazine, threaded muzzle, able to acquire that after July 1, but you won't be able to carry it on or about your person, because two features for acquisition, one feature for carry. Got it. Okay. So, again, convoluted because we're using the same weapon is sometimes an assault weapon in Virginia and sometimes not an assault weapon. Right. It's an assault weapon when you carry it, but not when you buy it. So it is, but it isn't, which is, I'm certain very comforting to all of you that are not lawyers.
Well, do you think, so that piece of the bill there, do you think that is something that the governor or the team would look at and just say, we need to clarify this? Is that something they could go back and ask them to straighten out? I mean, either for the good or the worse. I mean,
yeah. So of course they can. I mean, I don't know when exactly this is going to be released. We may have answers at the point it's released. My suspicion is that the governor does nothing with these bills because through inaction in Virginia, they still become law. I think she is probably going to run for some future political offices where she's going to try to claim she's a moderate. And she is probably savvy enough to be aware that if she signs a bunch of anti-gun legislation, it's going to get used against her in the future. People saying, hey, you're not really a moderate. Look at what you did to Virginia.
Right.
And so due to the way the law is set up in Virginia, because through inaction it can still become law, I suspect that she is going to sit back, not touch it, allow it to slide into law without governor's action, and then preserve sort of plausible deniability if you're not paying attention. Because if you are paying attention, you know that she was very involved in pushing this stuff forward.
Absolutely. And then she could have obviously
stopped it.
She could have stopped it.
That's right.
Yeah, sure. What about we were talking too about on concealed carry law and stuff like that. Getting a Utah permit, people that are, that want to do the right thing and carry in other states and also receive legitimate good training. In your opinion, what are some of the, I guess, the better carry ways there? Is this Utah or is this?
So I hate to break it to you. I think the Utah thing is not really that necessary.
Okay.
Here's my thinking on Utah. In Virginia, if you're going to keep your Virginia concealed handgun permit, they did not make substantive changes to what it takes to get a Virginia concealed handgun permit. One of the changes that will be important is if you're a Virginia resident and you're carrying on it, you moved here from Texas, you have a Texas concealed handgun permit, and you're just carrying here because your Texas permit is still valid. Once you become a Virginia resident, post July 1, you need to get a Virginia permit to keep carrying. Right. So that's one nuance. But outside of that, I don't see Utah as that useful unless you go to Delaware. And here's why. In Virginia, if you're heading south and heading west, for the most part, you're heading into constitutional carry states. North Carolina is not. Hopefully one day it will become a constitutional carry. But
surprising it isn't, but yeah.
Outside of North Carolina, you're heading into constitutional carry states heading south and west for the most part.
Yep.
If you're heading north or heading east, you're heading into locations that aren't going to recognize the Utah permit. So I think the only place you really pick up, realistically speaking, with the North Carolina permit is Delaware. And I'm not a Delaware attorney, but I understand Delaware recognizes a Utah permit. So that would be something you pick up out. If you go to Delaware all the time, by all means, grab a Utah permit. Outside of that, this theory that you're going to have reciprocity where you wouldn't otherwise have reciprocity, I think you're either going to, and the reason people are worried about that, back to your, I get carried away.
It's fine. Yeah, you're good.
My mind bounces around. But what they've done is post July 1st, the Attorney General will be able to review reciprocity agreements with other states and revoke reciprocity if the state does not have substantially similar qualifications for the issuance of a permit. So it is going to likely, and I don't want to talk my way into bad news, but I think Pennsylvania will lose reciprocity with. And again, I practice in Pennsylvania as well. We only just got, I actually, on behalf of Gun Owners of America, had a meeting with the Attorney General in Pennsylvania last year, and after that meeting was when Pennsylvania restored reciprocity with Virginia. I think it's likely to go away again. And why I think that is I think Virginia will probably revoke reciprocity with Pennsylvania. Virginia will say Pennsylvania's qualifications are not substantially similar because here in Virginia we require a class. Pennsylvania does not have a class requirement. So I think Virginia will say we're going to stop recognizing Pennsylvania. And as soon as they do that, Pennsylvania's policy is you don't recognize us, we don't recognize you. So I think Pennsylvania will stop recognizing Virginia at that point. But a Utah permit's not going to help you in Pennsylvania unless you happen to be a Utah resident, because Pennsylvania is not going to recognize a Utah non-resident permit. So,
gotcha. Yeah.
Very limited utility in running out and getting a Utah permit.
Well, that definitely clears up a lot of questions because there's several people that I know that they're really considering doing it, and they're like, I'm really not sure if it's going to help me or not. All I tell them is just don't go to Maryland with a handgun. It's not a very good idea.
Or go get, I have a Maryland wear and carry. You can get a Maryland non-resident permit.
Yeah.
Still don't be very cautious in Maryland. As we talked about a little bit, 20 minutes ago, Maryland will hammer you for gun violations.
Oh, man. Yeah.
But if you do go to Maryland, you should get a wear and carry permit.
Yeah, definitely. Well, I think we've covered the basis. You've got to get going down to the range and get this class. This is just a taste of some of the information that you can get. I would highly encourage people to look into Law Shield and becoming a member. There's a lot of benefits to it other than just legal advice too, right?
Yeah, and so Law Shield, in my opinion, does several things very, very well. one of the first things that I think is important for folks is they provide you the ability to access an attorney within a 48-hour window for non-emergency advice. And my phone has been I'm feeling it buzz away in my pocket. It's probably emails from Law Shield saying, hey, can you call this person? Can you call this person? Because lots of Virginians right now have, and for good reason, as you're hearing on how confusing this stuff is, have questions. So the ability to call in and talk to an attorney outside of having an emergency, I think, is huge. But even with and beyond that, beyond saying, hey, it's important to get good legal advice and not believe everything on the internet, I think what Law Shield does, in my opinion, better than anybody else, is Law Shield provides you access to an attorney that is licensed in your jurisdiction. And they do that on an immediate basis if you have an emergency. So I carry, and several other members of my firm carry, emergency phones that you can get us on 24/7 if you have a self-defense incident. And there's lots of self-defense programs out there that say they've got an attorney on call. But to the best of my knowledge, Law Shield is the only one that maintains an attorney on call in all of these different jurisdictions. I think every other program has some attorney sitting in Oklahoma City carrying a phone. But if you're a Virginia resident and are involved in a self-defense incident in Virginia and you call an Oklahoma attorney, arguably you don't have attorney-client privilege because you're not talking to an attorney licensed in your state.
Right.
Whereas, and even if you do have attorney-client privilege, what's that attorney going to know about the local laws, the local law enforcement? Are they going to know the prosecutors? That, are they going to be able to give you good advice in the moment? Law Shield, to me, their defining thing that they do better than anybody else is they get you on the phone with an attorney licensed in your state immediately when you have a self-defense incident. And I can't tell you how many people over the years, in my opinion, would have been charged with a crime had they not had the opportunity to speak with me at 2:37 in the morning when something happened and have me intervene on the spot in the moment and head off criminal charges. And if you do get criminally charged, even if you get not guilty a year down the road, you will realize that the process is the penalty in many respects. And so to me, that is a fundamental reason to look at Law Shield is unlike every other program that's out there, you're on the phone with a licensed attorney the instant something happens. And obviously I'm plugging this because I work for them, but also because I believe it's a very powerful tool to have at your disposal.
If you've got car insurance, health insurance, life insurance, I mean, this is no different in my opinion.
Sure.
I mean, it's
and that's where I'm sort of trying to hammer this point because that's what every other insurance provider in this industry talks about. Oh, you've got coverage, you don't need to worry.
Right, yeah.
There are some real cognizable, concrete differences that it's all well and good to say, oh, we'll buy you a new gun and we'll get you counseling services and all this other sort of, chrome on the outside.
Yeah.
At the core of the product is, can you get somebody that can give you legal advice in your state when something bad happens?
Yeah. Well, it's a fantastic organization. You're getting ready to go to a class at the range. We filled that thing. We scheduled 2 classes. I think we capped it at 40 people for the classroom for both classes. And we sold them out really fast. So much so, I think now we have scheduled a couple coming up in April and May. We're going to open up the store portion of the range, and we're going to put like 100 seats in there. And those are filling up. Those are starting to fill up too because you can sign up for those now. I believe through Law Shield, through Green Top Shooting Range. If you're on our email list, you get the emails. You can sign up through the email through the website too. So if you're out there, if you're interested, check out Law Shield. Go to their website. You can find links on greentop.com as well. Man, thanks for being here.
Yeah, thanks for having me. I'm looking forward to these classes as well. So.
Yeah, the classes should be good. I think you're going to probably get some interesting questions and some valid concerns from a lot of citizens of Virginia. And I'm curious to know how they're going to go.
Sure. Well, scary time to be a gun-owning Virginian.
It damn sure is. Well, Gilbert, thanks again for being here, for being on the show, and we'll love to have you back again. Maybe we'll wait and see what happens, and then we'll have you back on and we'll talk more in depth about what's more to come.
We'll be involved in litigation over this stuff, so
absolutely.
That's what's to come.